Everyone. Good afternoon, everyone. My name is Andrew Hall, and I am a senior counsel and shareholder for the Blake Law Firm. And I'm here to talk to you today about land licenses. There was a recent blog entry on our website called License to Use Land. And this webinar is meant to explain in a little bit more detail what that article is about and what you as a potentially someone who's interested in a land license should be looking for. So a quick overview of today's presentation. I'm going to go over what is a land license, and perhaps as importantly, what is not a land license. A distinction between land licenses and other common encumbrances that you may have heard of. Is a land license right for me? And then situations where a land license use might be warranted. So what is a land license? A land license, unlike some other encumbrances, can be formed either in writing or orally. A lot of encumbrances cannot be formed orally, so that's a unique feature of a land license, is to be able to do it orally. What a land license does is it grants certain generally revocable powers to parties to perform certain actions on land. The property, like for instance, an easement, the property that's burdened with the license is referred to as a servient tenement. You might have heard of that before. And the holder of a license is called a licensee. A license is a personal privilege held by an individual for the non-exclusive use of the servient tenement. What does that mean? Well, whereas an easement benefits one person in particular, the person holding the land license is not permitted to exclusively use it. And that's a key distinction between a land license and some other encumbrances. So what is a land license not? A land license does not grant any ownership of the land to the licensee. So the person holding the license does not own the portion of the land to which they're entitled to use. A land license cannot be transferred to another individual. It's unique to that individual person holding it. It does not create or convey an interest in real estate, and it does not endow the licensee with a right of possession. So there's common encumbrances that I'm sure many of you have heard of: easements, leases, adverse possession, and a land license kind of falls somewhere in between all of those. It's kind of the lesser known sibling of some of those common encumbrances. So how does a land license compare to some of those encumbrances? Well, an easement, unlike a license, creates an exclusive non-possessory interest in real property. Unlike a land license, which may be revocable, an easement's irrevocable. It cannot be withdrawn without the mutual agreement between the two parties involved with the easement. While a license is a personal right, unique to that individual holding it, an easement runs with the land. So an easement can be transferred down on the line as long as the land is transferred. And this means that subsequent property owners are bound by the terms of the easement. Whereas a land license, a subsequent owner of the property may not be bound by the terms of the license because it's unique to the individual and not to the property itself. Another common encumbrance that I'm sure many of you have heard of is a lease. What's a lease? A lease is an agreement between a property owner and a tenant granting the tenant the exclusive right to possess the property. So unlike a lease, land license holder does not have the exclusive right to possess the property. Others have the right to possess that property, that portion of the property subject to the land lease or the license. A lease is transferable and not revocable until the term of the lease has expired. A land lease could potentially be revoked at any time, whereas a lease runs for a specified period of time, whether that be a month, a year, 2 years, etc. And a lease, unlike a land license, connotates payment of rent. The holder of a land license may not necessarily be responsible for a monthly payment as you would be for rent or some other type of payment. And then there's adverse possession. And adverse possession does permit someone without any interest in the property, provided several factors are met, to legally use the land. And this requires that the property be possessed continuously, open and notoriously, for a prescribed period of time, depending on which state you're located in, and significantly hostilely. And this is often a very hostile point of contention between parties arguing over adverse possession, whether the possession of the land was hostile. An adverse possessor does not have the permission of the landowner to use the land, and that's kind of what the hostility speaks to, is that the landowner using the land has not given permission to the person occupying the land to use it. A land license, conversely, does require that a landowner allow someone to use the land vis-a-vis the land license. So one thing you may be asking is a land license right for me? And as you can see, there's certain encumbrances that may work in certain situations, but not in others. So what are some scenarios where a land license might work better than an easement, for instance, or a lease or adverse possession? So in order to determine whether a land license is right for you, you want to keep in mind some of its key features. One, it's revocable at any time, whereas an easement, as we discussed earlier, is irrevocable. So if you're a landowner that wants to grant a temporary right to use a portion of the property rather than an irrevocable right, then you may want to consider a land license. A land license is personal and cannot be transferred. Again, a person has a right to use the land vis-a-vis a land license, but if the person were to sell the land, then the land license would be extinguished and the new landowner would not have a right to use the land that is contemplated by the prior land license. It's not exclusive, meaning others can use a portion of the land contemplated in the land license, and it's not insurable. So when is a good situation to use a land license? A land license might be an option for you if you are looking for a temporary, short-term, or minor need. For instance, allowing access for service vehicles or guests. One anecdote that I have in a recent case involves a right of a neighbor to use electrical power sources and or a well on a person's property. It's possible that an easement was created in that situation where the parties really wanted to create a land license, a temporary use of those that don't run with the land and are unique to the person. So it's very important that, depending on the type of use that you want to use the land for, that it's clearly delineated, whether orally or in writing, that it's a land license, that it's temporary, that it's revocable, and that it doesn't run with the land. A land license might also be an option for a landowner looking to grant a more temporary right to another to perform certain actions on the land. So again, if you're looking for a temporary usage of the land, think land license. If you want something a little more permanent, then maybe you're looking at an easement, for example. Well, that was a brisk, quick overview of land licenses. As you can tell, there's a lot that goes into them, and it's important, depending on what you want to do with your property, that you consult with a knowledgeable attorney to help walk you through exactly what each of these various encumbrances entail, and whether a land license in particular is right for you based on the circumstances and situation that you're contemplating the use for the land of. If you have any questions or would like to discuss land license in general, please feel free to reach out and I'd be happy to discuss. Thanks for your time today. Look forward to hearing from you.